Please, my lord. My lady, may be allowed to mention item 21. My lady, the judgment, 21. Judgment which is under challenge was passed by my lady when she was the district session judge. So if an order may be passed that if this cannot be taken up.
Item 21. This is the matter.
Taken up before under the court.
Before any other bench, without me.
Lordship, let the matter fix on 8th of December.
8th of December.
All right, no problem.
List on 8th December.
Since both the councils are outstation councils.
It's okay, 8th December.
Lordship, yes, interim order may be continued.
There's an interim order.
Yes, Lordship.
The interim order passed earlier shall continue till the next date. Yes.
I'll look like.
May I please, Lordship? Lordship, item number 4.
Yes.
I may be given 3 weeks time to file my written objection.
Learned counsel for the respondent, sole respondent.
Lordship.
Mr. Sharif Hamid prays for 3 weeks time. 3
Lordship.
weeks, file an objection in the matter. So prayers allowed. Learned counsel for the appellant. Appellant, have you informed?
Lordship, I cannot contest.
Learned counsel for the appellant is not present when the matter is called. List after 3 weeks. Yes.
Lordship.
I would mention item number 26.
Item?
26 for him.
26. Yes.
After 2 weeks is 26.
You are for?
Let us come up after 2 weeks
No, in this matter, you are for respondent.
for the private responses.
Private respondent. Okay, Learned.
Your Lordship, I'm for respondent number 6. Lordship, and if the name of the leading counsel for respondent number 6 may be reflected in the cause list.
No, has it been entered in the CIS?
No, my senior is not here. I think I have with what was name? Yes.
Because only if the name is entered, it can be reflected.
Okay, Your
You
Lordship.
just check up, okay? Learned counsel for respondent number. Young are you for?
6.
No, young are what?
Respondent.
Private respondent prays for 3 weeks time. 2 weeks. 2 weeks time. So learned counsel for the petitioner has no objection. Learned counsel for respondent number 6, Mr. Such and Such submits that the name of the leading counsel has not been reflected in the cause list. So accordingly, the counsel shall inquire from the registry as to whether the name of the leading counsel has been entered in the CIS, and thereafter the registry shall do the needful. This after 2 weeks.
May I please, Your Lordship? Lordship, I beg to mention item number 7, Lordship.
7.
On behalf of my colleague, Itiba Pom, Lordship. Lordship, if this matter can come up after 3 weeks, Lordship.
3 weeks.
Yes, I'm appearing in person, Lordship.
Oh, okay. Learned PP, Mr. Vijimomi, makes a mention on behalf of Mr. Tibapom, Learned PP, who is appearing in the said matter, in the present matter, and prays for fixing the same after 2 weeks. After 2 weeks, stop. Mr. M.H. Mukam has the petitioner has no objection. List after 2 weeks. Yes.
Lordship, on the last occasion, the counsel who appeared failed to pray for the extension of the interim order passed. So I request to kindly pass the interim order earlier passed.
The interim order passed earlier shall continue till the next date. Yes.
Obliged, Lordship.
Mr. Tushitanjan appears for respondent number
1, Lordship.
1. Yes.
My Lord, may I be permitted to mention a matter?
Yes.
My Lord, item number 8.
Item 8. Yes.
My Lord, I am appearing on behalf of the petitioner. I already had a word. My brother colleague had a word with the learned State Council. Now today stands fixed for filing of an amended application, and my Lord was pleased to grant time to the state for another 3 weeks to file their reply. My Lord, I couldn't file the amended application within time, so I need some more time to file the amended application.
Okay, who's appearing? PP? You're appearing?
Yes.
Okay,
On behalf of K. Angami.
okay. Learned Counsel, your name
My lord, Mohammad Shamimuddin.
for the petitioner submits that he is yet to file the amended petition and prays for 3 weeks.
Yes, my lord.
Prays for
Yes, my lord.
3 weeks time to file the amended petition. So Learned PP is present. Stop list after 3 weeks. Yes.
My lord, if a date may be fixed, because there are two other writ applications that are also there along with this matter that has been fixed on the 4th of December. If this may be fixed on 4th of December, my lord.
Okay, list and 4 December.
Much of them.
But pleadings have to be completed before that. And
Yes, my lord.
the parties shall exchange their pleadings. Yes.
Much of them.
No, please, Your Honor. No, I beg to mention item 5, COP. This item has been tagged with WPC 178 of 125.
On 31/10/2025.
So it should come up with
Yes.
the
Yes.
Along with the
It's,
WPC.
it's listed on Thursday, this Thursday. Yes, Lord.
Learned
On
Counsel
6/11/25.
for the parties submit that this matter is to be tagged with WPC
178/2025.
2025 and list the same on
6/11/2025.
6/11/2025. Yes.
Obliged, Lordship.
Your Honor, I also beg to mention item 19. On behalf of K. Angami, we pray that this matter may be listed after 3 weeks. I have taken the consent of the petitioner.
On behalf of
K. Angami.
Learned Government Advocate Mr. M. Longkamar submits that Mr. K. Angami, the Government Advocate appearing in the matter, has some difficulties today, and accordingly prays for listing the matter when?
3 weeks. Your
After
Honor.
3 weeks. Stop. Learned Counsel for the petitioner. No objection?
No objection, my
No
lord.
objection. List after 3 weeks. Yes.
Obliged, Your Honor.
Lordship, I beg to mention item 20.
Huh.
This is a consensus prayer if it can kindly be listed after 3 weeks.
On the prayer of the parties, list after 3 weeks. Item 20.
Lordship, in item 24, the division bench of this honorable court is seized with the same issue in writ appeal 4 of 2025. As such, it may kindly be listed after disposal of writ appeal 4 of 2025.
Learned Counsel for the petitioner, Mr. Sentianger submits that a writ appeal being WA 4 of 2025 is pending before the division bench with regard to the same subject matter. With regard to the same subject matter, and accordingly prays for listing the same after disposal of writ appeal 4 of 2025. So the prayer is not objected to by the learned government advocate, Ms. Livika. So accordingly list after disposal of writ appeal 4 of 2025. Yes.
Deeply obliged.
May I please, Your Lordship, may I be pleased to mention item number 25, Your Lordship. Hearing item number 25 on behalf of AIME. Your Lordship, if this matter can come up after 2 weeks.
Petitioner?
No objection.
Yes, learned counsel for the petitioner, Mr. James Newman is present. Stop. Learned government advocate, Ms. Livika, makes a mention on behalf of the learned government advocate, Ms. AIME, who has some difficulties today to list the matter after 3 weeks.
After 2 weeks.
After 2 weeks. Stop. List after 2 weeks as prayed for. Yes.
Much.
Your Lordship, I also beg to mention item number 10. Your Lordship, here the petitioner will implement PNR as a
I have served
party,
copy.
Your Lordship.
Yes.
I received a copy, Your Lordship.
We'll be filing this morning.
Item 10.
Yes, my lord. There's an early order for implement of PNAR.
So it's done. Implement is done.
Yes, it is not done. We are filing the IA only today.
Okay. Learned counsel, item 10, learned counsel for the petitioner, Justin Tianger, submits that he will be filing an IA for implement of the principal secretary,
My lord.
the new principal secretary at the Department of PNR during the course of the day. And accordingly, prays for listing the matter when? After 1 week?
My lord, it is the Commissioner and Secretary PNR Department.
Okay, not principal secretary, commissioner and secretary PNR. It's
After 1 week.
Yes.
Deeply obliged.
Much obliged.
May it please your lordship, I beg to mention here in item number 22, your lordship, I'm appearing on behalf of my senior and Longkumar, your lordship. If the matter can come up after 2 weeks since my senior is at this post.
You are for respondent,
Yes, respondent number 3.
respondent 3. Learned counsel, Ms. Kim, appearing for respondent number 3, makes a mention on behalf of the leading counsel, Mr. N. Longkamar, who has some difficulties today to list the matter when?
After 2 weeks.
2 weeks. So learned counsel for the petitioner is present and has no objections, list after 2 weeks. Yes.
Obliged.
May I please, my lord? Lordship, I beg to mention item number 2. Lordship, I am appearing for respondent number 1 in this matter, Lordship. Lordship, may I kindly grant 3 weeks' time to get the necessary instruction, my lord.
Learned counsel for respondent number 1, Mr. N. Nangami, prays for 3 weeks' time to receive instructions on behalf of respondent number 1 and to file the affidavit. Stop learned counsel for the petitioner is present, MS Sergeant Sir is present, list after 3 weeks. Yes.
Lordship, I have a similar prayer for item number 3. Here I am appearing for respondent number 2 and 5, my lord.
Same prayer, 3 weeks.
3 weeks' time, my
3
lord.
weeks, but the respondent will be 2 and
5, my
2
lord.
and 5. Okay. And learned counsel for the petitioner, Ms. Sergeant Sir is present. Stop list after 3 weeks. Yes.
I am deeply obliged, my lord.
My pleasure, Lordship. Lordship, I beg to mention item number 13.
Item 13.
Lordship, on behalf of Tipapom. He still received the case diary, so kindly list this matter after 2 weeks.
He has not received.
Yes, Lordship.
May I please your lordship?
Yes.
Your lordship, I am on behalf of Mr. Italang for respondent number 2. Your lordship, we will be filing our vakalatnama within a week. So can you grant 4 weeks to file affidavit in opposition?
They have asked for 3 weeks, so let it come up after 3 weeks.
Oh, yes, your lordship.
Learned counsel for the petitioner, MS such and such is present. Stop learned government advocate, praying on behalf of the learned PP, Mr. Tipapom, prays for 3 weeks' time as he is yet to receive the updated case diary. Learned counsel, MS such and such appears, take their names, okay? MS such and such appears for respondent number 2 and submits that the leading counsel, Mr. Italang, will be filing the Vakalatnama today.
Your lordship, in a week, your lordship.
Filing the Vakalatnama within a week's time, and accordingly prays for 3 weeks' time to file the objections. So list after 3 weeks.
Your lordship,
There is an interim order.
The interim order passed earlier shall continue till the next date. Yes.
Lordship, I also like to beg to mention item number 26.
26.
Lordship, on behalf of Moim Jen.
26 is already mentioned.
Lordship.
Yes.
Oh,
Yes, your lordship. Your lordship, if I may allow to mention item number 18.
Yes.
Your lordship, here by order dated 22 of September, we were allowed to implead respondent number 5, for which we have implead already, and this is the IA for it. So if we may allow to amend the cause title in the main petition, contempt petition.
Okay. Already allowed implement.
Lordship.
Okay. So it should be disposed actually, isn't it?
Lordship.
IA 197. Can I just see IA 197? Kosa. IA 197, item 18. No, there's no order here. Maybe order was passed in the main petition. Huh? Give me the main contempt petition, 14. No, there's no order. On 28/10, You're talking about 2810,
22nd,
2210.
2209-2025.
No, Your Lordship, on 2810, they took time to file IA to implement the new Home Commissioner.
Yes, 2810 order
Yes.
says, Learned Counsel for Petitioner submits that he needs 2 weeks' time to file an IA for implementing the new incumbent. So today it's coming up, isn't it? No order has been passed allowing the implement.
No. Thereafter it was listed again on 2810.
You see the order 2810. Today only it's coming up, the IA. Learned Counsel, MS such and such appears for the petitioner / applicant. So, this is order in IA, okay? IA 197. So the petitioner, the applicant has prayed for implement of the new incumbent, Sri Abhijit Sinha, IAS Home Commissioner, as the newly implemented respondent number 5 in the connected contempt petition number 14 of 2025. Stop. Para. Learned Counsel for the petitioner submits that the contempt petition number 14 of 2025 has been filed, alleging willful non-compliance of the order dated 11/2024, passed by this court in WPC number 141 of 2020. Stop. Notice has been issued, and during the pendency of the contempt petition, Mr. Anup Kinchi, the then Home Commissioner, has been transferred out and is replaced by the new incumbent, Sri Abhijit Sinha, IAS. Accordingly, the petitioner prays for implement of the new incumbent as respondent number 5 in the contempt petition number 14 of 2025. Stop. Para. The prayer of the petitioner / applicant is allowed. Stop. The petitioner shall take steps to amend the cause title in WPC, in contempt petition number 14 of 2025, and thereafter implement respondent number, the new Home Commissioner, Sri Abhijit Sinha, as respondent number 5. Stop. After filing of the new amended cause title, the petitioner shall also take steps for service on the newly implemented respondent number 5 by registered post with AD as well as usual process within 1 working week. Okay, list thereafter.
Bless your Lordship.
My pleasure,
You
Lordship.
say list after 2 weeks. Yes.
My Lord, Lordship, if I may be allowed to make a mention, item number 9 on behalf of Mr. B.N. Sharma. Lordship, I have an instruction that he'll be filing objections to the IA file by the appellant. 3 weeks' time may be granted.
Learned Counsel, Mr. Sajid makes a mention on behalf of Mr. B.N. Sharma.
For respondent 1 to 4.
For respondent number 1 to
4.
4, who shall be filing an objection in the IA. Which IA? 58. In IA 58 of 2025. Stop. Learned Counsel for the petitioner is present. Yes. For the appellate is present. Stop. List after how much time?
3 weeks'
3
time.
weeks. List after 3 weeks. Yes.
Much obliged, Lordship.
All right, item number 1.
May I please, Your Lordship? Your Lordship, I have filed an affidavit on 8 October. I have filed 2 affidavits, Your Lordship.
Complied or?
No, Your
or to
Lordship,
comply or what?
No, Your Lordship, we are actually explaining the difficulties, Your Lordship, as to why the order of the Honorable Court cannot be complied. It is not.
What was the direction?
Direction is for granting scale of pay, Your Lordship, as per the advertisement, Your Lordship. And
Page
81.
And petitioners are on fixed pay.
Yes,
They-
still
they-
there. Even after the court has directed for granting scale pay to the petitioners on 16/3/2022. The judgment was passed on 16/3/2022,
What
Lordship.
is the difficulty?
No, Your Lordship, I have explained, categorically explained in my affidavit, Your Lordship, if you can kindly come to 8 November. I have filed on 8 November affidavit. Since there is two affidavits, so the latest one, 8 November, October, Your Lordship.
9th October is
8
there.
October, Your Lord, 8 October 2025.
Have you,
On behalf of R4, R4, respondent 4.
Yes, Your Lordship.
October, November, is this the one?
No, I have not done it. Your Lordship, there was a direction from the Honorable Court on 4/9/2025 to file the statuses after the appeal was dismissed. What was the step taken by us, Your Lordship, by the government? So, Your Lordship, I have categorically stated that we sought advice from the Advocate General, Your Lordship, after the dismissal, and there was an advice that there should be a review. And therefore, Your Lordship, a review has been preferred and it has been registered. However, till date, it is yet to be listed. Meantime, Your Lordship, because of the strike, Your Lordship, proposed by the RMSS teachers, Your Lordship, the high-level committee, Your Lordship, has been set up, Your Lordship. And they have also given a consent that within 6 months they will wait, Your Lordship, and within that the high-level committee will make a decision, Your Lordship. So in view of this, Your Lordship, may kindly grant some time.
Lordship,
You can kindly
unfortunately,
come to my petitions 5 and 6, Your Lordship. Paragraph 5 and 6.
What about their salaries? The court says salary of August and September.
Yes, we have released the salary of August, Your Lordship. However, September payment has been sanctioned, but because of the pen-down strike again, that is unable to, we are unable to release that, Your Lordship. Otherwise, August, we have already made payment. But for September, Your Lordship, because of the pen-down strike, we are unable to, though it has been sanctioned, Your Lordship.
Lordship,
Yes.
just my one humble submission is that constitution of committee by the government and these petitioners also agreeing to it, these are just outside the purview of this honorable court's direction, either on ignorance by both sides or so. Here, the question is whether paragraph 19, to grant them scale pay has been complied with or not is only the issue before this honorable court in this contempt, and that also is between this honorable court and between the government. Now
see,
they are saying that
The setting up of committee and
all
that,
those things does
the-
not
the
matter,
court is not concerned.
immaterial.
But a review has been filed against the SLP.
That,
Which
that
is
is,
pending.
they've been saying since the day I filed, since the day it came up, they've been saying this. Lordship, here one aspect is that whether review or whatever, Lordship, there is no stay and review.
There is no stay.
No, Your
There is
Lordship,
no stay.
it is yet to be listed. That is the problem, Your Lordship. It is yet to be listed in the apex court. It is registered, Your Lordship, but it is yet to, because of that, Your Lordship, we are unable to give the status. Otherwise, Your Lordship, if there is a stay or not, definitely, Your Lordship, we will be placing it before the court.
You have filed it on 14/8.
Yes, Your Lordship.
14/8, and it's still not listed.
Yes, that is the problem, Your Lordship.
I just hope and pray that it's not a delaying tactics. However, Lordship, can in review reverse the judgment and order dated 25/2022? It is not reversible, Lordship. I don't know for what purpose they have filed the review.
Their writ appeal was dismissed by the Supreme Court on 25/2025.
Yes, exactly, Lordship.
Then after that, they filed a review on 14/8/2025, which is not yet listed.
Yes.
That's what they're saying.
Review is for some inadvertent error or whatever apparent on the face of record to correct all those things. So where is the question of review of reviewing the paragraph 19? So here, both the parties, that is without my consent, Lordship, though I am before this Honorable Court for the petitioners, both have agreed to set up a committee or whatever. Those things are not, those things are immaterial before this Honorable Court in this contempt petition, Lordship. Until that, when they talk about the salary, they are talking about that fixed pay of 31,350 that was granted to them at the time of appointment. Now here is a question that we were appointed in a state creation post and in a state gather post. So we prayed for giving us our post-creation payment, and this Honorable Court was pleased to direct the respondent to grant us the scale pay, our post-creation payment. Nothing can reverse that. Nothing can outdo that, Lordship.
Otherwise, all the respondents have filed their affidavits.
Your Lordship, it will be more or less same. So, Your Lordship, on behalf of 4, Your Lordship, I have filed it. And at the time of filing this one, Your Lordship, the other petition were out of station. That's why, Your Lordship, I have filed only on behalf of 4.
The Right Learned Counsel for the petitioner, Ms. Z. Zimomi, as well as Learned Counsel for respondent number 4.
For all the contemners, Your
Okay.
Lordship.
As well as Learned Counsel, Ms. Livika, for all the respondents. So on 9/10/2025, this court had directed the respondents to inform the court as to what steps have been taken for release of the salaries of the petitioner for the months of August and September 2025. So, when the matter is called, the Learned Counsel for the respondents, Ms. Livika, submits that the salaries for August and September has
August already released. September yet to be released because of the pen down
August has
strike.
already been released, but September 2025 salary could not be released due to the pen down strike called by the Gansia.
Yes, you can see.
Called by the Gansia. Stop. As far as the prayer in the contempt petition is concerned, Learned Counsel also submits that a review petition has been filed. Where is the para?
15.
Para
Yes,
5.
Para 5.
Oh, 5.
And next year will be
That
page
a
7.
review petition has been filed on 14/8/2025 against the order dated 20/5/2025, passed in SLP Civil number 19524/2022. Stop. However, the same is still pending for listing and passing of orders. Stop. It is therefore prayed that some time may be given to the respondents/contemners to comply with the judgment of this court. And
Lordship,
how much time?
my prayer is that let it be subject to the outcome of the review, or maybe
will
till
go,
the review. Because
years,
review, I
Lordship.
think once it gets listed, it
No,
will be.
that cannot be. Lordship, how can that be?
We'll give 4 weeks. We'll see whether by that time it is listed.
Okay.
To list the matter after 4 weeks. Stop. Yes, list after 4 weeks.
Much
For
obliged, Your Lordship.
For admission, item number 6.
Obliged, Lordship.
Please, Your Ladyship.
Yes.
Respondent number 5 is yet to appear, Your Lord. And respondent number 6 is yet to file the affidavit in opposition.
Respondent number 6 is yet to file. And respondent 5
Is yet to appear.
not appearing. Otherwise, service complete.
Otherwise, service is complete, yes. Respondent 1 to 4 has already filed.
Learned Counsel for the petitioner, Miss, your name?
And Solo.
Solo is present. Stop. Learned, who is appearing for the respondents? None appears.
Respondent 1 to 4 is
What
the
about
NIA.
this PP? Oh, PP is also not present. Learned Public Prosecutor for the respondent number 1 to 4 is absent. However, they have filed their affidavit.
Yes, yes.
Stop. However, the affidavit in opposition has been filed on behalf of respondent number 1 to 4. Stop. Respondent number 5 has failed to appear in spite of notice. Stop. Respondent number 6 is also represented, but the affidavit in opposition has not been filed, and none appears for respondent number 6 today. Stop. List after 3 weeks.
Okay.
List after 3 weeks.
Much obliged.
For orders, item number 11. May it please your lordship.
Yes.
Your lordship, here the response they are yet to appear, your lordship.
Miss S. Chang was
Yes,
supposed to appear for
on behalf of
R3.
S. Chang, respondent 4. We are yet to receive instructions on
Respondent 3.
Yes, your
Not
lordship.
4.
Your lordship, here the other respondents 1, 2, 3, 1, 2, 3 and 5 they are yet to appear, your lordship.
Learned Counsel, Mr. M. Longkumar, makes a mention on behalf of Miss S. Chang, who's appearing for respondent number 3, and prays for another 3 weeks' time
Yes, Your
to file the affidavit on behalf of respondent.
Your lordship, if I may be allowed to make a small
Yes.
submission, your lordship. Here, your lordship. The contempt petition was filed for the non-compliance of the order dated 24/06/2025, your lordship. If your lordship would go to page number 20, your lordship. Direction have been given, your lordship.
Page 20.
Page 20, your lordship. Paragraph number 10, your lordship. Lordship, here, direction was given to the respondent's authority to consider the case of the respondents, your lordship, before he retired, your lordship, on attaining the age of 60 years, your lordship.
Before the petitioner's date of retirement.
Yes, your lordship. Your lordship, which was on July 31st, your lordship. Now, your lordship, I've already retired, your lordship. Lordship, after that, the respondents, they have not considered my matter, your lordship. Now, 4 months have lapsed, your lordship. And your lordship, if your lordship would appreciate the fact that the respondents, they are based in Kohima, your lordship. All the respondents, your lordship.
But then the notice is not yet served.
Yes, your
You
lordship.
see the office note.
Yes, your lordship.
3010 also, it says service of notice in respect of 1, 2, 4 and 5 still awaited.
Yes, your lordship.
So,
Your lordship, if endeavor can be met through the respondents, your lordship, that the other respondents.
or you can take steps by Dusty.
Your lordship, that's the, your lordship.
That is better. Learned Counsel for the petitioner's present. What did I say last time? And please for 3 weeks' time to file. No order passed. No? Yes. 3 weeks time on behalf of respondent 3. Stop. The office note dated 3/10/2025 indicates that service of notice in respect of respondent number 1, 2, 4 and 5
4
is
and 5.
still awaited. Stop. Accordingly, the learned counsel for the petitioner is permitted to take steps on the respondent number 1, 2, 4 and 5 by Dusty, and thereafter to file an affidavit in respect of the same. Stop. List after 3 weeks.
Lordship, much obliged. For orders, item number 12.
This is also contempt.
May I please, Your Lordship?
Yes.
Your Lordship, here the Honorable Court order has been complied with.
Okay.
Yes, Your Lordship, by office order dated 21st July 2025. Your Lordship, so
Learned counsel for the petitioner is present. Learned counsel for the petitioner, Ms. Agency, is present, and submits that the direction of this court by order dated 12/3/2025 in WPC 227/2022 has been complied, and an order dated an office order open brackets part -2 Roman 2 close bracket number /29 dated 21st July.
yes, Madam.
Dated
21st July.
21st July 2025 has been passed by the respondents in compliance of the same. So accordingly, she submits that the matter may be closed. So Learned Counsel for the respondents number.
Your Lordship, I'm for respondent number 1.
Respondent number 1, Mr. Nangami, Ms. Vishokri for respondent number 3, and M.
4 and
Kumar
5.
for respondent number 4 and 5 are present. So the matter stands closed.
Obliged, Madam.
Obliged.
For orders, item number 14.
May I please, my Lord?
Yes.
Lordship, I have taken steps upon respondent number 3 through Dusty as well as usual process, through registered post as well as usual process on 8/10/2025, as directed by this Honorable Court dated 26/9/25.
Service reports not returned. Learned Counsel for the petitioner, Sri Sergeant such present. So Learned PP, Mr. V. Jimami is present for respondent number
1.
1. Stop. The notice, series of notice on respondent number 3 is still awaited as per office note dated 30/10/2025. Stop. Accordingly, this is the matter after 3 weeks awaiting service on respondent number 3.
Lordship, there's an interim order.
What about 2? Who is respondent 2?
Respondent to Lordship is Government of Assam.
Oh. So what about 2 then? Have you served?
Lordship, I have not served upon respondent number 2.
If you have impleted, then you have to take steps.
Lordship, this Honorable Court has stated that respondent number 2 shall not be made a necessary party. So no steps need to be served upon the respondent number 2.
By which order?
Lordship, it was Lordship, it's not mentioned in the order.
Then 11 PP is, are they necessary party? State
Lordship.
of Assam.
I don't think they are the necessary parties. Since the FIR has
Because
been
the
lodged.
case is of Nagaland.
The cases of
Yes,
Nagaland.
then why it's state of Assam has to
Lordship.
be a party? It is found that the respondent number 2 has been wrongly impleted. And accordingly, the respondent number 2 is struck off from the list of respondents in the coastal. Stop. List after 3 weeks, what did I say? Awaiting, awaiting service report on respondent number 3.
তো আমি কিন্তু দুজন মিলাই কিনে একটু স্টাম্প পেপারে প্রিন্ট আউট করে দিবি এগ্রিমেন্ট একবার স্পেলিং চেক করে দিবি স্পেলিং চেক করবি তাই হাতামতে প্রিন্ট আউট করবি
Lordship, interim order may kindly be allowed to
The
continue.
interim order passed earlier shall continue until the next date.
Obliged.
Obliged.
For orders, item number 15.
May I please, Lordship? Lordship, as per the previous order dated 9/10/2025, this honorable court allowed the appellant to file affidavit of compliance with regard to the substituted notice through paper publication which the appellant have taken. So, Lordship, we have drafted our affidavit and we have sent it to the office of the insurance company for vetting. However, we yet to receive it from their end, Your Lordship. So, if 2 weeks' time may be granted, Lordship, to file our affidavit of compliance.
You have taken to paper publication for which respondents?
8 and 9, Your Lordship.
8 and 9. Learned Counsel for the appellant, Mr. M. Vero, is present. Stop. It is submitted that this court right order dated 9/10/2025 had allowed the appellant to file the affidavit in compliance reflecting the notice of service on respondent number 8 and 9 within 2 weeks. Stop. However, Learned Counsel submits that the affidavit has been prepared and sent for signature and prays for another
2 weeks' time.
2 weeks' time to file the same. Stop.
Lordship, I am for respondent number 1 to 7.
Praise allowed. Stop. Learned Counsel, Mr. Sharif Ahmed appears for respondent number 1 to 7, and Mr. M. Longkamar
On
appears
behalf of K. Angami, respondent
on
11.
behalf of Mr. K. Angami appears for respondent number 11. This is the matter after 2 weeks.
For orders, item number 16.
Lordship, I think response number 1 and 4 has been written, which I've sent it to register post AD, Lordship. If I may be allowed to make correction in the AD and send it again, Lordship, for respondent
But
number
the
1.
address, you have to ascertain
The address is same, but because of the contact number, the postman could not,
locate.
yes.
Learned Counsel for the applicant, Miss Kim Pen is present. Stop. It is submitted that, no, the office note dated 30/10/2025 indicates that service report in respect of respondent number 1, 5, and 7 is still awaited. Stop. In respect of respondent number 1 and 4, the notice had returned unserved with insufficient address remark. Stop. Accordingly, Learned Counsel for the applicant submits that she may be given some time to take fresh steps. No?
Lordship, if I may be allowed to correct the AD acknowledgement address, AD, and then send it back.
After that, you have to send it back. No?
Yes, yes.
That she may be allowed to correct the address in the AD card and resend the same. So that means you have to take it back from the registry.
Yes, Your Lordship.
The registry shall allow the petitioner's counsel to take back the returned AD card for doing the needful. Stop. List after 3 weeks.
Congrats, Your Lordship.
For orders, item number 17.
My lady, may I please, my lady? I'm for the respondent 1, 2, the claimants. My lady, the IA is for condonation of more than 30 days. My lady may be given some time to file a affidavit. Objection.
Objection.
Objection to the delay of more than 30 days.
Learned Counsel, Ms. Kim Pen is present for the applicant. Stop. Mr. Fosiko for the appears for the claimant respondent number
1 and 2.
1 and 2, and praise for how much time?
3 weeks.
3 weeks time to file an objection in the IA 174, no? 174 of 2025.
174, yes.
Yes.
Stop. Praise allowed list after 3 weeks.
Lordship,
What about the other respondents?
they have not appeared yet. It's still written that it's awaited.
In respect of respondent number 3 and 4, the service report is still awaited.
Congrats, Your Lordship.
For hearing, item number 23.
May I please, Your Lordship? Your Lordship, here the petitioner is challenging the appointment order dated 15 November 2023, issued by the Director Rural Development. My Lord, here, during the year 2010, the petitioner father was approached by the concerned department for establishment of Rural Development Store at Kifri. So, my Lord, the petitioner father, on the assurance by the department that a quid pro quo will be given to the landowner. So, on that assurance, the petitioner father had donated the plot of land. Now, my Lord, may kindly come to page 14, that is annexure 2.
Yes.
Yes, Lordship, here the land was donated in the year 2010. Now, despite of several efforts before the concerned department, it was only on the 9th of June 2023. The block development officer had also written a letter to the deputy commissioner to issue for the land ownership, landowner certificate. Now, accordingly, my lord, the deputy commissioner had also kindly come to page 15, clause A. That is the type copy, lordship. So, accordingly, the office of the deputy commissioner had also given a direction to the BDU, block development officer, to produce the written documents or agreement signed between the concerned department and the landowner. Now, my lord, on the instruction of the department, on the instruction of the RD department, they've also made one agreement, that is at Annexure 3, page 16. I may be allowed to read the relevant part at third para. In whereas the donor generously agreed to donate a plot of private land measuring in the area of so-and-so at DC Ward, Kifri, which was roughly made and executed in the year 2010 on the pretext of extending service benefit. My lord, here again, and whereas the donor, in sound mind and without any coercion, had agreed to provide credit for a progeny, as in when vacancy arose. Now, Your Honor, basing on that, the office of the deputy commissioner had also given the landowner certificate. That is it, page 17. Now, my lord, here on being learned about one vacancy arose in the department, the petitioner had also made an application, which was duly forwarded by the concerned department, which is at page 20. 20, my lord, which was accordingly forwarded by the block development officer to the director, Rural Development, Nagaland. Now, my lord, despite of all this, the department has appointed the respondent number 5, who is also not the landowner. Also, my lord, as I've already stated in my para 11, lordship. Para 11, lordship. My lord, despite of the applicant, the concerned department had appointed the respondent number 5 without any following due process of law. So, my lord, the petitioner is here before this court for appointment on the basis of the land ownership, my lord.
Any others from your family appointed?
No, lordship, no.
Yes, that is our main contention of the government, lordship.
The petitioner's father's name is when did you file your affidavit? Government affidavit?
It was filed on 23rd of April 2024. Affidavit in opposition.
Respondent 1 to 4, no?
I filed two. One is additional affidavit, which was filed last month. But affidavit in opposition was filed last year, Your Honor.
Yes.
Have you got it, Your Honor? Your Honor, if you come to my affidavit in opposition, para 3, but firstly, I want to take you to page 4 and 5. The last, page 5, Your Lordship. On verification by the department, it was found that the father of the petitioner, Sri S. Leni Sanctum, was appointed on land ownership basis to the post of peon under the establishment of RD Blocks, Kifari, by order dated 26/8/1997. So the benefit of employment has already been availed, Your Honor. And as per with the strength of the notification dated 5/3/2018, we're not permitted to give employment for the next descendants. And secondly, the contention of the government is that they are relying on this agreement on which they have annexed in page 16. But this agreement is not valid, Your Lordship. Well, this was signed by the PDO. And as per the Nagaland rules of executive business, it should be signed. I have annexed in page 10 of my affidavit of the persons who can sign a document, an instrument of the government. Page 12 of my affidavit in opposition.
Yes.
Section 12. May I read, Your Honor? Orders or instruments of the government of the state shall be expressed to be made in the name of the governor and shall be signed either by an officer mentioned in Rule 2.1 or such other officers as may be authorized by the government, and such signature shall be deemed to be proper authorization of such order or instrument. Now, if you come to Rule 2L, it's in page 10. So 2L says, Secretary means a secretary to the government of the state of Nagaland and includes Chief Secretary, Additional Chief Secretary, Principal Secretary, Commissioner and Secretary, Special Secretary, Secretary, Additional Secretary, Joint Secretary, and Deputy Secretary, and Under Secretary. So, Your Honor, this block development officer is not authorized, and he has never been authorized by the government to enter into such an agreement. And moreover, this agreement was not in existence at that time. It was made only instantaneously after the DC had asked for documents calling for records. This was made only after the DC's letter, Your Honor. And here in the reply to my affidavit, the petitioner has alleged that this is a different plot of land, this agreement. It relates to it. But however, Your Lordship, there is no such second plot of land. It is just one plot of land which was given way back in the 1970s.
This agreement is a very recent one.
Yes.
This is 23.
Yes.
23. Whereas you said that your father had donated the land way back in
2010, Lordship.
2010. And have you enclosed the appointment order of the petitioner's father?
Yes. It is in my page 11, page 15 of my affidavit in opposition. 16 is the typed copy.
Yes, if your father has already been appointed on the basis of land ownership, then as per the OM,
My Lord.
you are not eligible.
Yes, my Lord. I'll come to that part, Lordship. Lordship, here now the state respondent as well as the private respondent have stated that the petitioner father had already availed in the year 1977. However, my lord, the present petition, it arose, which was given in the year 2010. It is a different land. The department has approached for extension, and they've taken another plot of land. So this is different, Lordship. And then, my lord, regarding for the affidavit or no, after the department has taken the plot of land in the year 2010, the petitioner had also approached the concerned department for more than 10 years. However, since, the department only in the year 2018, they've also made an application to the deputy commissioner. So only on the instruction of the department, the petitioner had met this agreement, Lordship.
Then what about the 2010 agreement? There is no written agreement in 2010.
At that time, the petitioner was assured that a great purpose will be given. So in lieu of that, no compensation, no any sort of compensation have been given.
No agreement, no agreement.
Yes, Lordship. They have already agreed. Now, my lord, in the affidavit filed by the private respondent,
No, you have to prove your case first, then
Yes.
only the private respondent will come. Anyway, what did the private respondent say?
Lordship, if we carefully, if I may, if we carefully peruse the agreement in page 16, on the paragraph that they are relying upon. May I read, Your Honor?
Yes.
Whereas the donor generously agreed to donate a plot of private land measuring an area of such and such at DC Ward, Kifre, which was roughly made and executed in 2010, on the pretext of extending service benefit of the donor, hereinafter referred to as the Leni Sanctum. So this is only, there's no, even looking at this, there's no condition or even accepting that there was an agreement. However, Your Honor, the
Then
condition.
what about
Yes.
this 1974?
yes, my lord.
1974,
Yes,
2010, 2023.
In the year 1974, they have, the petitioner great grandfather had donated a plot of land. There they have already established the rural development office. Now in the year 2010, again the department had approached the petitioner father for the extension as well as for the establishment of rural development office cum store. So accordingly, they have already agreed on that. So it's a different land.
Your Honor, the petitioner first needs to prove that there was a second land. They have not been able to establish any such fact, Your Honor.
In 2010, they asked for another extension.
Yes.
So this
Then-
2023 agreement is in regard to that extension?
Yes, Lordship. As per the OEM, they have verbally agreed that a great purpose will be given. However, in the year 2010, when the land was donated for the extension.
I think an inquiry is required. Because if the department had asked for another plot of land, and that agreement was there to provide employment.
But as far as my instructions, Your Honor, there is no such second plot of land, as far as the department is concerned. That was my instruction.
And even in the agreement of 23, it doesn't say anywhere that employment will be
Yes,
given.
yes.
My lord, coming to fourth para,
Acha, acha. On the pretext of extending service benefit to the donor. So this Lenny Sanctum is already appointed.
Yes.
no, my lord,
Of
my lord,
extending service benefit to the donor, referred to as Sri S. Lenny Sanctum.
my lord, this matter pertains to 2010, which was donated in the year 2010.
No, but where does it show that the father of the petitioner was appointed on landowner basis?
It's not mentioned specifically.
Because this is 97,
Yes.
he was appointed
Yes.
in 97.
Yes, Your Honor.
And by that time, they still had not donated the land, isn't it? You donated only in 2010.
Yes, lordship. Yes,
The
lordship.
land which the department knows aware is that is the land which was donated in 1974.
Oh, acha, acha.
That is how this agreement also started as the,
Between the grandfather.
yes, between the grandfather, that's the original donor. And since the father was already appointed on temporary basis, we can only conclude reading of this pretext of extending service would only mean that to extend the service of the person who was already appointed on temporary basis. We cannot construe that the department has made a promise to employ another person. However, we still contend that this agreement is not valid, Your Honor. Because this BD concerned officer signed without authorization, due authorization.
But in other cases also,
Yes.
we have seen many agreements where it is only the administration who has signed, or the departmental officer who has signed, and not the secretary or undersecretary, because they are usually in Kohima.
Yes.
And the district officers usually sign the agreements
Yes.
on behalf of the government.
Yes, lordship.
Your Honor,
So
on that, yes, on that
cannot be a
regard,
very,
yes, it is written here that they have mentioned the list of officers who can sign. However, the second part of page, section 12 says, or such other officers as may be authorized by the government. That is true, Your Honor. Anybody can sign, maybe some other officers, but with authority. They should be duly authorized, Your Honor.
Lordship, in my reply, I've already stated that since the block development officer is the head of the district, at that time when the
Where have you stated about
Kindly
donating
come
an
to-
additional plot?
Yes.
No, additional plot of land.
Can,
Because here, you have not stated anything about the 1974 donation.
my lord,
And now you're saying that the 74 donation and the 2010 donation are different plots.
yes, yes, Lordship, that
But-
is why
but
in my,
in your petition, you have
yes,
not
para
stated-
number 4, I've stated that in the, that some years back in the
No,
year
that- This
2010.
is only 2010.
My lord, since the petitioner is not concerned with the other plot of land, but the petitioner is concerned about the land which was given way back in the year 2010 for the extension.
So you mean to say that 1974 was donated by your grandfather?
Yes.
And 2010 was donated by your father?
Yes, yes, Lordship. And then this agreement was passed which was donated in the year 2010.
We'll just give a direction to the Deputy Commissioner to conduct an inquiry, okay?
Lordship, yes.
Because there is some confusion.
Okay, my lord, my second condition is that even interview and selection process was not conducted as per the.
No, that,
So, my
if
lord-
you can establish your right, then you can challenge it. But if you don't have a right for appointment, then you cannot challenge the appointment of the private respondent. No?
Yeah, Lordship.
That's the thing. You have to first establish that you have a right to be considered for appointment.
My lord, in that case, my lord,
Yeah, we will just keep it pending and we'll give a direction. During the course of hearing, it has been brought out from the records that the petitioner's grandfather had donated land for establishing the office of the RD block Kifere in the year 1974. Stop. The contention of the petitioner is that his father had thereafter donated another plot of land in the year 2010 to the same department, no? That is the Rural Development Block Kifere. Stop. However, the learned government advocate, Mr. M. Nongkamar, contends that there is no second plot of land and that the petitioner's father has already been appointed on the basis of land ownership in view of the land donated in 1974. Stop. And therefore, in view of the paragraph 3 small c of the notification dated 5th March 2018, the petitioner is not entitled for appointment. Stop. Para. At this juncture, it is considered necessary for this court to direct the Deputy Commissioner Kifere to conduct a verification as to whether the land donated by the petitioner's family in 1974 is the same plot as the one donated in as the one allegedly donated in 2010, and whether the agreement dated, where was that? Page
16.
page 16, Lordship, at annexure 3.
And whether the agreement dated 26/6/2023 is in respect of the land donated in 1974 or in 2010.
Yes.
Stop. The Deputy Commissioner is also directed to ascertain the donor of the land donated in 1974 and the donor of the land donated in 2010. Stop. The Deputy Commissioner shall submit the said report. How much time? 4 weeks.
Yes, Your Lordship, if I may take you to, just indulge for a moment. The notification, which says that any, in the first, 1A. Notification,
1A.
yes, notification dated 5th March 2018, the Land Revenue Department. 1A says that it has been laid down by notification dated 26/7/2005 that no land shall be acquired free of cost, and all land shall be acquired on full payment, compensation, or as determined by law. No further condition for employment in service contractual works shall be entertained. Therefore, in case any department has entered into any agreement with the landowners in deviation to this late policy on or after 2005, such agreement shall be treated as null and
So
void.
yours is 2010.
Yes.
My lord, however,
So that is against this notification.
my lord, however, as I've already stated in my para, at the time of acquiring the land, no sort of compensation was even given to the petitioner. It was only on the verbal assurance that a great purpose will be given in lieu of the land.
No, you're talking about the 74 one.
No, even in the 2010.
No, that's why 2010 such a condition could not have been put at all as per this notification. And the land could not have been donated. You could not have donated free of cost. That's what it says. Yes. Now the cutoff date is 26/7/2005 and yours is 2010.
Yes.
So this second alleged donation is illegal, is against this notification. Okay, delete this. We'll dispose it of, dismiss.
My lord, my second contention is that regarding the appointment and all, it was neither selection was made nor advertisement has been made.
Okay, agreed. But whether you have a right to challenge, that is the whole thing.
Lordship,
Yes.
that context,
Yes.
may be allowed to establish that the petitioner is not locus standi, since his father is already.
Locus, yes.
That's not locus. Lordship, my lady has already in a similar matter in the
Yes,
PPC
yes.
72.
Yes,
before.
that's why.
And even in UPC 9 of 2023. So the court has passed
That
orders
cutoff
stating
date,
that.
it's good that you
Yes.
pointed out that cutoff date. Because 2010, such an agreement could not have been entered into at all in 2010.
Yes, my lady.
And in view of 74, your father is already appointed.
My lord, similar matter has been disposed by this honorable court in WPC 133 of 2023, lordship.
No, the facts and circumstances may vary from case to case.
My lord, may kindly come to para 25.
25.
Yes, lordship. Para 23, 25.
Here, I think there was a selection process. There was a selection process and the petitioner also participated, isn't it?
Lordship, this matter also pertains to the landowner.
No,
where
no,
the-
landowner,
yes.
but still. You come to para 7. In the additional affidavit in opposition so filed by the respondent 1 to 6, such and such stated that petitioner did not apply on land ownership basis. The only aspect which was mentioned as regards the appointment of the respondent number 7 was that the respondent 7 was appointed in view of an approval given by the government, right, such and such. It was further mentioned in the said affidavit in opposition that 13 appointments have been made on the basis of land ownership. However, it is pertinent to observe that both the pleadings of the respondents are not clear and specific as to whether the petitioner's family donated the land or whether any member of the petitioner's family had been appointed on land ownership basis. There, they had not specifically stated that anyone was appointed. Here, they are specifically stating that your father has been appointed.
My
That is the
lord.
difference.
Yes, my lord, however, my contention in para 14 is that in my main petition, I have already stated in para 11 that no such procedure has been followed. Now, the additional affidavit filed by the state respondent, my lord, may kindly come to additional affidavit filed by the state respondent, my lord. My lord, here the state respondent have stated that the appointment only two application has been received by the concerned department. Now, my lord, in my reply, I have already stated that
Yes.
on being learned about the vacant post, the petitioner had also applied for the same post, which was forwarded to the concerned department. However, my lord, on the basis of recommendation made by the minister, without conducting any sort of examination or selection, without allowing the petitioner even to appear for the interview, the respondent number 5 was appointed, lordship. Despite of the glare of his memorandum, which I've already annexed in my annexure 1 of my reply to the additional affidavit, lordship.
For that specific point, Your Honor, even the petitioner herein has been duly recommended by their concerned MLA, the chairman. They have also enclosed a copy of the minister concerned, even the petitioners.
My lord, in my annexure 1, reply to the additional affidavit, lordship.
Reply to additional affidavit.
Yes, lordship.
Reply to government affidavit.
Yes, yes, lordship.
Para?
Para 2, lordship. My lord, coming to annexure 1, which I've annexed office memorandum dated 3rd March 2022, lordship. In my reply to the...
I think your reply to respondent 5.
Yes, yes, yes.
Not government.
reply to the additional affidavit, Lordship.
Yes.
Yes.
That's one. Filling up of grade.
Yes,
group
despite of
depots.
the clear office memorandum. My lord, here, despite of the office memorandum, despite of all this, the state respondent
So
has-
what is respondent number 5 say?
May I please, my lady?
Yes.
My lady, firstly, the respondent number 5 has raised an issue on maintainability and filed an IA 133. On locus, stating that when the petitioner's father has already been appointed, the petitioner doesn't have any locus to challenge the appointment of the respondent number 5. And only on having stand of locus standi, his fundamental or legal rights will be violated. Here, such has not been done so. The petitioner's father has always been appointed on land ownership basis. Even Lordship, in the continuation of the submission made by the government, saying that with regard to the agreement was entered into in the year 1974, and in 1997, the petitioner father was appointed, and he's still in service as per the affidavit of the government. Now the respondent, the petitioner, could not show that he has donated another land, only by this one agreement, which is also null and void. And as per the OM 2018, this agreement does not stand. It's illegal. It's null and void. Otherwise, so this honorable court, in a very similarly situated matter, I may be allowed to place.
Against that, an appeal has been filed in the DB.
Yes, even even otherwise, my lady, the petitioner has to prove that he has another land, and on that basis, an agreement has been entered between the the petitioner and the government. But as per the OM, even he has donated land, they could not have entered into any agreement after 2005, as per the notification of 2018. And my contention is that since the
Okay, but
petition-
another, on the flip side, if you just look at it, if the petitioner had appointed had applied as a general candidate, not as a landowner. Yes. And there may have been other applicants also. So, could respondent 5 had been appointed straight away like that? When, in spite of other applicants also being there? Not considering that he is a landowner. If he's not a landowner and if he had just applied on general, as a general candidate.
The records show that as at least as far as the private respondent and between the private respondent and the petitioner, the government has duly considered the documents in hand and the qualifications, the private respondent has a higher qualification as compared to the petitioner by one class class 8 and class 7. But even that situation, Your Honor, the agreement that you're relying upon is wholly invalid as per the notification. Maybe at best they can, before the appropriate forum, they may ask for compensation. But as far as the government policy is concerned, no more appointment conditions after 2005.
My lord,
Yes.
coming to a reply made by the private respondent at para 5. Now the private respondent has stated that the appointment of respondent number 5 has stated that the state respondent considered his candidature with approval order for appointment. So basing on that, only the private respondent was appointed. Now, my lord, there's a clear office memorandum, which I've already annexed in my annexure, that if the appointment has to be made on the basis of land ownership or on the compassionate, the advertisement should be dispensed. However, my lord, without any advertisement, without any, despite of putting up all the application and all, no for interview and all, the.
No, but then here you are specifically coming on land ownership basis. You are saying that you have to be appointed because you are a landowner. That is your entire ground in this petition.
That is why, my lord,
You are not saying that I have applied, others have also applied, but respondent 5 was appointed.
My lord, that is why I've already stated in my paragraph 14 that without following the employment policy, my lord. Para 11, lordship.
No, that's why you have stated that you should have been appointed, but.
My lord,
but-
at para 14, lordship, para 14.
See, even if the appointment of respondent number 5 is quashed, doesn't mean that you will be appointed on land ownership basis.
My lordship, if the appointment is quashed, then as per the office memorandum, it should be come up with an advertisement, lordship. Because the appointment was made only on the basis of recommendation made by the minister, lordship.
May I please, Ma'am,
Yes.
even otherwise, the agreement was entered into in 2010.
Which is
after
against the
against the
notification.
OM.
Yes.
So the petitioner doesn't have locus to challenge the appointment of the respondent 4. I mean, we allowed to place the judgment of the Supreme Court, 2013, Volume 4, ACC. Volume 4, ACC 465. Relevant para is at para 9. Para 9, page 475. I mean, we'll have to read. It's at the bottom. Aggrieved person. It is a settled legal proposition that a stranger cannot be permitted to meddle in any proceedings unless he satisfies the authority court that he falls within the category of aggrieved person. Only a person who has suffered or suffers from legal injury can challenge the act, action, order, etc. in a court of law. A writ petition under 226 of the Constitution is maintainable either for the purpose of enforcing a statutory or legal right, or when there is a complaint by the appellant that there has been a breach of statutory duty on the part of the authority. Therefore, there must be a judicially enforceable right available for enforcing, on the basis of which writ jurisdiction is resorted to. The court can, of course, enforce the performance of a statutory duty by a public body using its writ jurisdiction at the behest of a person, providing that such person satisfy the court that he is a legal person to insist on such performance. The existence of such right is a condition precedent for invoking the writ jurisdiction of the court. It is implicit in the exercise of such.
There's no doubt.
So, and a legal right.
My
Means
lord,
entitled
here,
arising out of a legal rule.
as
And
per this authority,
the agreement, statutory, there's no breach of any statutory law here.
If his appointment was challenged by some other person who had also applied,
my
then
lord,
maybe
yes, my
the
lord,
situation would have been
even the
different.
petitioner is also aggrieved because he has also made the application. However, no selection process has been met. My
No,
lord,
but
may
if you are a
kindly,
landowner, no selection process is required.
And
If you are a landowner, straight away you'll be appointed.
no, that
If
is
you
why, my
can
lord.
prove your right.
My lord, that is why.
the
Yes.
government,
If the petitioner has also applied for the post, and then now the concerned department has appointed respondent number 5, who is not the landowner.
Let someone else challenge, let someone else who has also applied challenge. Yes, heard learned counsel for the petitioner, Mr. Kushi Tamjit, as well as Mr. M. Longkama for the state respondents. So also heard Mr. Foseko Fote for the respondent number 5. So, the petitioner, by filing this writ petition under Article 226 of the Constitution of India, has challenged the appointment of the private respondent number 5 as MTS under the establishment of Rural Development Officer RD, Kifri Nagaland. Stop. The petitioner is also aggrieved by his non-appointment on the basis of land ownership against the said post. Stop. The contention of the petitioner in the present writ petition is that in the year 2010, the petitioner's father had donated a plot of land for the construction of office of the Rural Development Block, Kifiri, Nagaland. Stop. It is also stated that at the time of donating the land, the landowner and the RD department, Government of Nagaland, had agreed orally for appointment of a grade 4 post. And during that time, the department was asked to rectify/verify the real owner of the land, and had written a letter dated 9 June 2023 to the Deputy Commissioner Kifiri to verify and to issue the land ownership certificate to the father of the petitioner. Stop. The Extra Assistant Commissioner Kifiri, Nagaland, white letter dated 19 June 2023, had written a letter to the Department of Rural Development, directing them to produce the letter of agreement signed between the department and the landowner. Stop. Para. In pursuance thereof, the department and the landowner executed an agreement between the parties, wherein in the said agreement, the concerned department had agreed to provide grade 4 appointment to the landowner as and when vacancy arises. Stop. The Subdivisional Officer, Civil, Office of the Deputy Commissioner Kifiri, Nagaland, also certified that the petitioner's father is the donor of the land. White letter dated 9th August 2023. Stop. Para. Upon learning that one grade 4 post of MTS had fallen vacant under the establishment of BDO Kifiri, on the retirement of one Sri Tsipong Se Sangtam, TSE PONGSE Tsipong Se Sangtam, the petitioner, being the landowner, approached the concerned department for appointment on the basis of land ownership by submitting all required documents. And accordingly, the BDO Kifiri forwarded the same to the Director, Rural Development, Nagaland, Kohima, by letter dated 16th May 2023. Stop. Para. The petitioner also submitted an application to the department for appointment on the basis of land ownership, and the same was forwarded to the Director, Department of Rural Development, by the BDO Kifiri. Stop. However, instead of appointing the petitioner on the basis of land ownership, the Department of Rural Development appointed the respondent number 5 against the existing vacancy without following the employment policy which is followed in the state of Nagaland. Stop. Para. It is stated that the respondent number 5 has been appointed in violation of the office memorandum number AR-GEN-174/2007, open brackets, PT, close bracket, dated 3rd March 2022, which mandates that Group D post such as Chokidar, Mali and Pion are filled up by landowners or on compassionate ground in the district, subdivision or village level, and therefore the condition of advertisement is dispensed with whenever such difficulties are faced by a department. Stop. Learned counsel for the petitioner therefore submits that only in cases of landowner appointment or compassionate ground appointment, the condition of advertisement is dispensed with, and therefore the respondent number 5 could not have been appointed without due advertisement. Stop. Para. The petitioner also states that none of the family members of the petitioner had been appointed on the basis of land ownership. It is also stated that the case of the petitioner had been examined and recommended by the district administration of Kifiri, and as such, the case of the petitioner falls under the purview of the land ownership policy, Vite notification number LR/6-181/LIT/2015, dated 5th March 2018. Stop. Learned counsel for the petitioner therefore submits that therefore prays that the appointment of the respondent number 5 as well as the administrative approval dated in 13/11/2023 issued by the Deputy Secretary to the Government of Nagaland, Department of Rural Development, may be quashed and set aside, and the petitioner may be In your prayer, there's no prayer for appointment, only for quashing. Directing the director to quash and set aside, and then nothing is there to appoint. Anyway, praise for direction to quash and set aside the in search of respondent 5, nah? And also praise that the petitioner may be appointed on the basis of land ownership in the said vacancy of MTS in the office of the BDO Kifiri. Stop. Para. Learned Government Advocate Mr. M. Longkumar, submitting on the basis of the affidavit filed on behalf of respondent number 1 to 4, submits that so what is this annexure 1 in your affidavit? Government affidavit?
There's a Nagaland Rules of Executive Business, which states the persons who can sign a government instrument.
Okay, then annexure 2.
Yes.
Wait, okay.
Annexure 2 is a notification.
And this annexure 2 is the number of candidates who had applied.
I believe you are on the other affidavit, Your Honor. It's affidavit in opposition.
Oh, okay.
Yes,
This is additional affidavit.
Yes, Your Honor.
There are 2 affidavits. now.
Yes. First is the additional.
Yes. Additional affidavit on behalf of
Filed on 23rd April 2024.
there are 3 affidavits. Government affidavit?
Yes. It is the affidavit in opposition. It will be in the heading. The rest are just clarifications.
Okay. Is the government advocate submitting on the basis of the affidavit in opposition submits that the BDO Kifiri does not have the authority to enter into an agreement on behalf of the government of Nagaland. Stop. It is submitted that Section 12 of the Nagaland Rules of Executive Business 2020 categorically states the list of officers who can sign orders or instruments on behalf of the government. So, the BDO Kifiri was never authorized by the government to enter into such an agreement, and as such, the agreement signed by the BDO Kifiri is not valid. Stop. Moreover, it is stated that the father of the petitioner, Shri S. Lenny Sanktam, Lenny, Sri S. Lenny Sanctum, has already been appointed on land ownership basis to the post of peon under the establishment of BDO Kifire, White Order dated 26/8/1997, and he is still in service. Stop. And as such, the question of appointment of the petitioner on land ownership basis does not arise, as it would be in violation of Section 3, Clause C, 3C of the notification dated 5th March 2018. Stop. The learned government advocate therefore submits that the petitioner does not have the locus standi to claim for appointment as a landowner, and nor to challenge the appointment of the respondent number 5. So, learned government advocate also submits that the notification dated 5th March 2018 at paragraph 1A has also laid down that any department which has entered into any agreement with the landowners in deviation of the laid down policy on or after 26/7/2005 shall be treated as null and void. Or you do one thing, you just take down this entire para 1A, reproduce. At para 1A has stated as such, and then you reproduce para 1A. Stop. The alleged agreement executed between the Rural Development Department and the petitioner's father was made in the year 2010. No, sorry, was executed in the year 2023. No? Was executed in the year 2023, isn't that the agreement?
Yes, 2023.
It was executed in the year 2023 for the land which was donated in 2010, and therefore the said agreement is in violation of the condition laid down in clause 1A of the notification dated 5th March 2018 and has to be treated as null and void.
Your Honor, if I may, for the land alleged to have been donated in 2010.
Alleged to have been donated.
Yes.
Alleged to have been donated in 2010. Has to be treated as null and void. Okay. Stop. In view of the above submissions, learned government advocate submits that the petitioner has not made out a case for the interference of this court, and the petition should be dismissed. Better. Learned counsel, Mr. Fosse, for appearing for the respondent number 5. Has also adopted the submissions made by the learned government advocate and submits that the petitioner's father has already availed the opportunity of being appointed on land ownership as per the policy of the government by notification dated 5/3/2018. Stop. He has also submitted that the petitioner therefore has no locus to challenge the appointment of the respondent number 5, as he has not been able to establish his right as a landowner, supported by a valid agreement to provide employment. Stop. Para. Before coming to that, in the petitioner submission, you just add one more paragraph, okay? Learned counsel for the petitioner has relied on the case of Srimati Imsunaro, Imsunaro, versus State of Nagaland, in a judgment passed by a coordinate bench of this court in WPC 132/2023, wherein the court, by judgment dated 27/8/2025, had quashed and set aside the appointment of the private respondent who had been appointed without following due process of law. And the court had directed the respondent authorities to fill up the vacant post of MTS by carrying out fresh selection proceedings. Stop. It was also held that the claim of the petitioner for appointment on land ownership basis shall be subject to scrutiny in terms of the notification dated. What is the 16/8/2018 notification? The notification dated 16/8/2018. It's okay, it's okay. Stop. Then you come down. New para. This court has considered the submission of the learned counsel for the parties and has perused the pleadings and the documents annexed thereto. Stop. The perusal of the alleged land donation agreement dated 26/6/2023 reveals that an agreement had been made in the year 1974 between the grandfather of the petitioner and the Department of Rural Development. Stop. And it is stated in the agreement that service benefits shall be extended to the donor, referred to as Shri S. Lenny Sanctum. Stop. It is also reflected that the Department of Rural Development agrees to provide grade 4 opportunity as and when vacancy arises to the donor. Stop. The notification dated 5th March 2018 has specifically laid down that no land shall be acquired free of cost and all land shall be acquired on payment of full compensation. Stop. It is also laid down that no further condition for employment in service or contractual works should be entertained, and that any agreement in deviation of this policy after 26/7/2005 should be treated as null and void. Stop. Therefore, on the face of the records, the land donation agreement dated 26 June 2023 is ultra-virus, being in violation of the notification dated 5th March 2018 and has to be treated as null and void. Stop. Para. In respect of the agreement made in the year 1974 between the petitioner's grandfather and the Department of Rural Development, which is not denied by the state respondents, the petitioner's father has already been appointed by an order dated 26/8/1997 as peon in the establishment of RD Blocks Kifere, and he is still continuing in service. Stop. In view of the above, it is seen that as the landowner has already been appointed, the candidature of the petitioner on the basis of land ownership cannot be considered in view of clause 3C of the notification dated 5th March 2018, which provides that employment to the landowner in perpetuity is not the policy of the government. Stop. The employment of a landowner is limited only to the person first appointed as landowner in government service and does not entitle his descendants for further employment on his retirement from service. Stop. The case referred by the petitioner can be differentiated from the present case inasmuch as in WPC 132/2023, the official respondents had not made any averments in the affidavit as to whether any member of the petitioner's family had been appointed on landowner basis. Stop. In the present case, it is the specific averment of the government respondents supported by the appointment order of the petitioner's father that the appointment on the basis of land ownership has already been provided to the petitioner's family. Stop. In view of the observations made above, this court is of the view that the petitioner has not been able to make out the case for the interference of this court. The petitioner also has no locus standi to challenge the appointment of the respondent number 5, and therefore the petition is dismissed. Stop. has to pass. Let someone else challenge his appointment. Someone who has applied. Then the court can do something.